Judges would find that another civil revision had been filed
Yes.
with regard to that order. That was ultimately withdrawn and a new work proceeding was started. Then at
Yes.
page 112, petitioner number 2, who was the chairperson of the ad hoc committee, he had come up before this court as well. And again, the court had passed an order. The relevant portion is at page 114, where everything was relegated back to the work tribunal to be decided.
Yes.
Now, in this background, the work tribunal has been hearing the matter, and in the middle of all of this, a writ petition was also taken out by the complainant. Now, that order is at page 128, and this is where this particular controversy starts.
Yes.
Now, this writ petition, your lordship would find, is moved in December 2024, and the order that is passed essentially is at page 130, paragraph 15. In view of the above, the instant writ petition is disposed of by directing the Chief Secretary to consider the representations dated so and so and so and so, strictly in accordance with law, and upon giving prior opportunity of hearing to all the necessary parties, dispose of the same by passing a reasoned order the earliest and possibly within a period of 8 weeks. Till a final decision is taken by the Chief Secretary, the bank account of the Masjid ul Noor Masjid shall not be operated. So the bank account could not be used. Now, in the meantime, the masjid had to be administered. There had to be some committee, something which would look after things. So for this purpose, an ad hoc committee was set up. Now, your lordships would get that particular order at page 93. Now, all these things I'm stating are not factual matters because this is on record as part of the inquiry conducted by the police. So at page 93, your lordship will get order dated 14th August 2023.
Yes.
The petitioner number 2 is the president of the ad hoc committee. 2 to 7 are the others. The lady is nowhere connected with this committee. Now, once this committee is set up, thereafter, the committee realizes that it needs a bank account and it needs money. So for that purpose, we have asked the Waqf board for permission to open a bank account. My lord will get that at page 198. So the opening of the bank account is not an action done in isolation on our own to steal money.
Page?
Page 198. This is addressed by the petitioner number 2 on behalf of the ad hoc committee to the chief executive officer of the Waqf board, where he says that we need a bank account to be functional. The masjid does not have any PAN card, and since it's not registered under the Society's Registration Act, it can't have a PAN card. So therefore, please allow us to operate the bank account, the president, secretary, and treasurer. Now, your lordship will find on the next page, page 199, the chief executive officer of the Waqf board grants us that permission to open the bank account. At page 200, which is the next page, and none of these are disputed. These are prosecution documents taken by the police and placed on record. At page 200, sorry, a little unclear matter. This is the entire committee takes a resolution as to who will be permitted to operate the bank account. Number 1, Shahul Hamid, that's a petition number 2, president. A. Sheikh Asif Ali, he's a treasurer, he's not before the court. Abdul Latif, he's a secretary.
Yes.
Thereafter, at page 201, the lordship will get the bank account opening form which we submitted. In accordance with the permission granted by the Waqf board and the resolution of the ad hoc committee, the account is opened in the name of the Masjid in Noor, but it's operated by these 3 persons. So their 3 photographs are there. At the bottom left, your lordship will find the full name of the account holder is Masjid in Noor.
Yes.
3 persons' specimen signatures are there. Thereafter, my lord will find from that page up to page 206 is the form. Nowhere is there the signature of the petitioner number 1 wife or anything to do with her. Now, in this background, we have submitted documents to the bank for opening the account. Those documents, page 207 is the ad hoc committee, 208 is the masjid registration details, 209 are the KYC details, Aadhaar and PAN of those 3 persons again. Once again, the lady's name is not there. Now the controversy comes at page 230, which is the passbook for the account. The complainant, without understanding the way in which a bank works, has read this passbook, your lordship will see the third line in the middle. Now the second line, name, Masjid-e-Noor, joint name, Mr. / Messrs. Shahul Hamid, son of so and so. Thereafter, under the stamp of Andaman and Nicobar State Cooperative Bank, my lord will just be able to make out the words Abdullah. That was Abdul Latif, the second authorized person, and the third, Asif Ali. There's no place in that particular thing. But what they have focused on is Mr. / Mrs.
Mrs.
Now, this is a format used by any banking authority or any bank. On the basis of this, they have said the wife is the account holder, the wife is part of this entire thing, and the wife has fraudulently defrauded the money. So this was the first allegation of the wife. The second allegation with regard to the bank account, my lord will kindly see the next page, 240.
Yes.
These are the accounts, the entire statement with regard to this account. And at page 218, your lordship will find on the 16th of April 2025, the ad hoc committee submits everything. Now, before coming to this, I need to just give your lordship the background there. What happened was Ramzan was coming around. Now, during Ramzan, there has to be someone administering the mosque. This ad hoc committee was in place. But the complainant went back to the Waqf tribunal and said, put us in charge. So the court passes an order at page 115. (1.5) is the order of the Waqf Tribunal dated 6 September 2024. Again, a detailed order is passed by the court and the injunction is granted. The matter is then adjourned to October. But in the meantime, for that Ramzan period, page 135, an order is passed. No, I'm sorry. Page 132. This is dated 27th February. The relevant portion, my lord, will get at page 133 at the bottom. Considering that the holy month of Ramzan will commence in the starting of March and the affairs of the masjid is required to be taken care of, the petition filed by the plaintiff is allowed. Defendant number 1 is directed to form the ad hoc committee to look after the affairs of the masjid during Ramzan. Defendant number 1 is also directed not to violate the provision of the bylaws of mosque, etc. So a new committee is set up. So for this reason, the old committee had to be closed down. So in order to close down that committee, your lordship would find several orders being passed by the Waqf board by which one by one the committee was shut down. So page 126 is that order. The first order, I think, is at 124. At 124, the Waqf board passes an order on 3rd of December 2024, dissolving the ad hoc committee. But the mistake they made was they said let the earlier committee continue to run it, which was contrary to the court's position. And we'll get that at paragraph 125. At page 125, the last paragraph. The ad hoc committee constituted via letter dated 14th August will dissolve. The account opened in the name of Masjid-e-Noor is to be operated by Qadir Baba, president of TIM Kingsmill, committee existing prior to the constitution of ad hoc committee. Now this goes against the writ order because the writ said no one is to touch that bank account. So correcting this, they pass a fresh order after 2 days at page 126, where they say the relevant portion is at page 127. The last paragraph, the ad hoc committee is dissolved. The mode of selection of persons who can operate the account opened on so and so shall be decided subject to the outcome of the case in the Waqf tribunal. So therefore, the ad hoc committee has closed down. The bank account was to be closed. Those orders, your lordship, should get at page 179 and 180. Again, the closure of the account was done under the aegis of the administration. Page 179, the CEO of the Waqf board writes to the branch manager of that bank and says, this is the situation. Chief Secretary has now said to close the account, so please close it. And the order of the Chief Secretary I also annexed at page 180, where the Chief Secretary says you don't need 2 names, you don't need 2 accounts. This is creating unnecessary confusion. Just choose one name and stick with it. Now that order is at page 180 and 181. For this reason, we now submit all the documents, and that submission your lordship will get at page 218. At page 218, my lord will find on the 16th of April 2025, the committee submits all their things. But what is most important here is serial number 2, the receipt books, set number 1 and set number 2. Now, in set number 1, your lordship will find in the right hand column used receipt 001 to 573 for the first set of books. The second set of books 001 to 289. So essentially, one book is used for members, one book is used for donations by non-members. This position meant that you could have a receipt 001 from either book. Now, on the basis of this, the matter was sent to audit, and the audit report is ultimately coming at page 221. The audit report notes that the income tax provisions have to be complied with. That has not been done. The audit has been conducted only for 2 financial years, but that was a period for which the committee worked. They don't include assets and liabilities because we don't have that, and other documents are not available. But the audit report, I know the date is very vital. At page 222, the last line, 8 August 2025. Now, along with that, page 223, 224, balance sheets and everything else is there. Now, kindly see what are the allegations sought to be leveled against us. My lord will have the 156.3 itself, we have not been able to obtain, but at page 190, we've annexed the FIR where the 156.3 is reflected. Page 190 is the formal FIR. The 156.3 is there at reproduced on and from page 194. 194 from the middle of the page is the 156.3 application. The second, the verses part, my lord will find the petitioner number 2 is mentioned at serial number 2, and the petitioner number 1 is mentioned at serial number 3. What are the allegations at page 195, if I may place it? And these are allegations on affidavit. Page 195, the complainant are permanent resident. 2, the accused person residing at the address. 3, relevant portion is 6. That on 14th August 2023, the Chief Executive Officer illegally constituted an ad hoc committee by giving illegal name of Masjid-e-Noor in place of Masjid-un-Noor. 7. That on 10th June, Nasser Khan filed a suit being so-and-so for permanent injunction restraining the aforesaid person from using the unregistered name. 8. That on so-and-so, Nasser Khan and 9 others submitted a representation to the defendant. 9. Bylaws were approved. 10. Name board is depicted as this. 11. Marriage certificate. 12. This is the correct name. But which of these is a criminal allegation of a cognizable offense? These are all relating back to the civil proceeding. Identity. 14. That President Shahul Hamid, in connivance with his wife and others, opened a saving bank account in the name of Masjid-e-Noor, VDA account number so-and-so, dated so-and-so, without any authority, and collected an amount of so-and-so from the Tamil-speaking Muslim community by the above persons and cheated them and misappropriated them. This is the allegation. Now, without proper authority is absurd because the authority came from the administration and its functionaries. Thereafter, kindly see 16, that the ad hoc committee constituted on 14th August illegally collected the following amount. For example, the amounts are tabulated hereunder along with illegal receipts, and he's given all the receipts. Now, why were these receipts mentioned? Because there are duplication of receipts. So one from book 1 and one from book 2, they have taken it and shown that there were 2 receipts being generated with the same serial number, therefore there was a fraud somewhere. What they did not realize is that there are 2 receipt books. Thereafter, my lord will find 17, the aforesaid above mentioned persons joined together with a common intention to commit an offence, collected the aforesaid amount, misappropriated the same, and as such committed criminal conspiracy. These are the allegations against us. Now the magistrate has absolute authority to do so in terms of the judgments of the Supreme Court. he sends the matter for an inquiry and a report because he's not satisfied that a cognizant offence is made out. That order is at page 136. (136) is an order dated 30th April 2025. The relevant portion is at page 137, the first paragraph. As the SHO PS Aberdeen as well as the Superintendent of Police did not take any action against the opposite parties, so the complainant prayed before this court for a direction upon the SHO PS Aberdeen for initiating FIR against the OP accused persons for cheating, misappropriation, criminal breach of trust with common intention, that is so and so, by treating this petition of complaint as an FIR. As per the provisions of 175(3) of the BNSS, I think it is necessary to consider the submission made in this regard by the police officers. Hence, a report should be called for from the concerned SHO stating his submission in regard to this case. Hence, it is ordered that the SHO PS Aberdeen is directed to file his report inserting his submission in this regard to the incident as alleged by the petitioner complaint and submit a report by 5th of June. Now, the inquiry report comes in, that is at page 143.
Who's appearing for the private complaint?
We have made them a party, but after the admission and on your lordship direction, we will observe.
Yes.
Page 143. This is the forwarding report of the police report. And the police report itself, my lord, is at page 145. I beg your lordship's pardon. The first and second page have got interchanged. But I will just show your lordship the conclusions at page 144. This is the best copy we could get from the court records, my lord, because certified copy is not being given to us. So I will just read it. Certain parts are legible. I'm really sorry for. Paragraph 5, conclusion. The issue regarding the unauthorized bank account has been resolved.
Just.
On page 144 in the middle.
Yes.
Para 5, conclusion. The issue regarding the unauthorized bank account has been resolved following the closure of the account as per Chief Secretary's order.
Yes.
The dispute over the name of the mosque, Masjid Noor versus Masjid A Noor, has already been addressed by the CS and no further action is required regarding the same. Number 3, it has been confirmed that the bank account was jointly held by Sri Shahul Hamid, President, Sri Abdul Latif, Secretary, and Sri SM Sheikh Asif Ali, Treasurer. Srimati Shaira Banu, despite being implicated in the initial complaint, was never part of the management team or involved in the bank account. This confirmed her claim that she was wrongfully dragged into the matter for harassment purposes. She had no direct involvement with finances or the opening of the disputed bank account, which supports her defense. Next, the allegations of issuing double receipts with the same number were also ruled out after it was clarified that the receipts came from 2 different books used for entirely different purposes. On physical verification of these receipts, as alleged in the complaint, that is receipt number 4, 24, 194, 226, have been checked and found that one of them belongs to membership subscription of the masjid and the other meant for contribution towards masjid expenses. Therefore, it is requested to kindly file this complaint since none of the allegations have been substantiated against the alleged parties. This was a closure report. Now, when this closure report comes, there is one thing which, in all fairness, the police should have said, which they did not say. Now, kindly see the date of this report, my lord. This is being placed before the court on the 6th of August. Your lordship will again get that from the FIR. I'll come to that in a moment. But why it is relevant is the audit was what was required. The audit report would exonerate everyone clearly. Now, the audit report was sought to be collected by the police, but it was not ready. What had happened is, my lord has seen, we submitted everything in April. It was sent for audit. The administration wrote to the police. Kindly see page 166. The police had requisitioned the receipts and all the documents. And the CEO writes back, with reference to your letter dated so and so on the subject cited above, it is submitted that the ad hoc committee constituted with a letter dated 14/8/23 has been dissolved, with the order number 32 dated 5/8/24. The account details, cash book, etc. has also been collected from the ad hoc committee of Masjid-e-Noor and is under submission to a chartered accountant for audit. The audit report, as soon as it is received, the same shall be submitted to you. However, the copy of the relevant pages of the receipt book as asked and are enclosed for your ready reference. This is the first statement. The second statement, my lord, will find we have specifically found the audit report coming in. Okay. Now, my lord, will kindly see page 194 once again, which is the my lord, will see the top part is the order. This is the certified copy which we still haven't given.
Which page?
Page 194. The top half of the FIR.
Yes.
Now, what has happened is the police has come with its closure report. The de facto complainant is recorded as vehemently objecting and arguing and saying that there's a double receipt, this lady is there, the police said the lady is not there, there's no double receipt, the magistrate was satisfied. But then the magistrate says, where is your audit report? Now the police at that point of time should simply say, we asked for it, it's not yet ready, when we get it, we place it. The police officer, for whatever reason, did not say so. Now what the magistrate records is this. Order number 5 dated 6 August 2025. Today is fixed for hearing in presence of the inquiry officer. The record is taken up for accordingly. The inquiry officer and non-advocate are present. Heard the EO on doc who submitted that during preliminary inquiry, no incriminating material has been found against the accused persons and the allegation of criminal misappropriation of property would not be made out. On the contrary, the learned advocate for the complainant vehemently objected the report of the IO, specifically pointed out towards some of the documents annexed with his application. On being asked, the EO could not adduce satisfactory answer as to whether during the inquiry he had verified those documents or not. In that event, I think that the inquiry conducted by the EO is half-hearted and thorough investigation is needed. Considering the above, SHO is directed to register the complaint as an FIR and to start investigation by deputing a competent officer not below the rank of SI of police other than the present EO. Now, the difficulty here is under the law laid down after Lalita Kumari and Preeti Agarwala and Priyanka Srivastava, whatever statements are made on 156.3 on affidavit, the magistrate has the power to direct a preliminary inquiry. Now, when my learned friend for the state said investigation is in progress, I wonder whether my learned friend has gone through the records with regard to this because the investigation is completed. The inquiry report and all its documents verified everything except the audit report. Now, my lord, I said that date was important. This order is passed on 6th of August. The audit report is dated 8th of August. So, had the audit report come in and been on record, perhaps the situation would have been that satisfactory answer would have come that there's no misappropriation because the other offenses by themselves don't make out a case. Now, in this background, this 156.3 order is unjustified. Why? The law laid down by the Supreme Court is on a 156.3 application, if you're satisfied there's a cognizable offense, you straight away say FIR. It's when you're not satisfied, there's an overwhelming civil flavor. At that point of time, you call for a preliminary report. Now, if the preliminary report has come saying closure, you have to apply your judicial mind, consider the materials, consider the evidence collected, and pass a reasoned order. If you are not satisfied, a further report could have been called for that you answer these questions. In fact, the report answers each and every one of the questions except the audit report. Now, in that background, my lord, my humble submission is an order under 156.3 is something which creates very serious consequences for a person. In a dispute which has such an overwhelmingly civil background, this, in fact, is something which has to be noted. The Waqf Tribunal is the same. The same learned officer is presiding over all the civil matters and is aware of that entire background. My lord, a one-line order saying that the inquiry officer is giving unsatisfactory answer, so I'm directing an FIR, is something which causes extreme prejudice because in this FIR, they have the only person they have left out is the chief secretary who passed the order. The Waqf board, the CEO, the law secretary, the president of the committee, everyone has simply been wrong. Now, I am appearing for two persons. As far as the lady is concerned, my lord, it is very clear, the complaint is signed. As far as the gentleman is concerned, there is already a closure report in his favor. In this case, actually, all that That audit report has to be placed on record, and the magistrate has to satisfy himself whether there's any allegation made out of it. This order by itself cannot stand. So this is my submission. At this point of time, my lord, I realize the complainant will have to be heard. We will serve them, they will come, they will be heard. But at this point of time, my lord, these petitioners require protection.
Take note.
Lordship. Yes.
Yes, yes,
Regarding interim order, Lordship,
yes.
then objecting in respect of investigation, further investigation, because Lordship, in respect of the accused, first FIR, first information report, it is nothing only formal restriction of the FIR regarding the cognizable law, not in respect of any accused who was committed. But their second
But
part is
your report itself said there is no
Lordship
offense.
report, that is inquiry report which was asked by the court.
Correct,
Inquiry report that was inquired by the police officer. But
correct.
second part is, if a judicial magistrate found that the report is not satisfactory, Lordship, kindly appreciate this part. And it is passed in the order.
He's found it to be not satisfactory only on the basis of the audit report.
Not, I will come to the order, Lordship. May I come in? I will be allowed to read, Lordship. The page number 190.
Yes.
Just a middle portion. The EO and the landed advocate are present. Heard the EO and doc which submitted that during preliminary inquiry no incriminating material has been found against the accused person and has allegation of criminal misappropriation of property could not be made out. On the contrary, the landed advocate for the complaint vehemently objected the report of the IO and specifically pointed out towards some of the document annexed with his application. On being asked, the EO, inquiry officer, could not adduce satisfactory answer as to whether during the inquiry he had verified those documents, Lordship. My landed friend saying about the audit report. No, case, entire case, not based only on audit report, Lordship. Because those documents have been specified by the trial court.
So the CGM could have asked for a further report.
Lordship, it is those verified record, and second part, the landed judicial magistrate found the further investigation record, because that was the inquiry report, Lordship. Kindly appreciate. After that, 9th August, FIR have been chopped up. Lordship, investigation, my respectful humble submission, investigation respect of not in a person, accused person, in respect of the cognizable offense. Let us investigate the matter. If he is innocent, Lordship, file a procedural report again will come, Lordship. Opportunity is there. Opportunity is there.
So any innocent person should come to the police station and give statements, right?
Lordship, my respectful submission, Lordship, is the inquiry
Even
report.
prima facie when there is no
Lordship,
allegation against.
Lordship, FIR is not encyclopedia. Sometimes only disclosure of the cognizable offense.
Why should an FIR be lodged?
Lordship, regarding cognizable offense. My respectful submission regarding cognizable.
Only on the basis,
name is not FIR.
only on the basis of some allegation.
Lordship, of course.
There is no
In
allegation.
FIR, only allegation. My respectful submission, only cognizable offense.
All right, you
Who
made
has
the
committed part of the investigation.
All
That is my respectful humble.
Take note. The petitioner in the present proceedings are challenging the order dated 6/8/2025 passed by the learned Chief Judicial Magistrate Port Blair in RC NCR CR case number. What is the case number? CR 62 of 2025, whereby the preliminary investigation report submitted by the investigating officer was rejected. The learned magistrate further directed the registration of an FIR against the petitioners and ordered investigation to be conducted by deputing a competent officer not below the rank of sub-inspector of a police station other than the CO who had submitted the preliminary investigation report. Full stop. The allegation of the de facto complainant, complainants. Complainant is one or
No, Manu, there are three.
complainants? Complainants are that the accused persons mentioned in the complaint committed offenses of cheating, misappropriation of funds, and criminal breach of trust with common intention, thereby attracting the provision of section 318, 3184, right?
3184, 3165, 356.
3184, 3165, 3635 of the BNS 2023. Full stop. Despite filing complaints before the concerned station house officer and the superintendent of police, no action was taken. Full stop. Consequently, the de facto complainant filed an application under section 175.3 of BNSS 2023 before the competent Chief Judicial Magistrate, Port Blair, seeking direction to the SHO, Aberdeen, to register a case against the 9 accused persons named in the complaint and to reinvestigate the matter by treating the complaint as an FIR. Full stop. While order dated 30/4/2025, the learned judicial magistrate directed the SHO Aberdeen to submit a report based on the allegation of the de facto complainant, pursuant thereto, the investigating officer submitted a report dated 11/7/2025, concluding inter alia as follows. ये page 144. Conclusion. पूरा लिखो. Yeah. Page 144, 5 conclusion. Tick to tick. The matter was again listed before the learned Chief Judicial Magistrate on 6/8/2025. Full stop. The investigating officer failed to satisfactorily confirm whether he had verified the documents relied upon by the de facto complainant. Full stop. In view of this, the Chief Judicial Magistrate directed that the complaint filed by the de facto complainant be registered as an FIR and ordered investigation by deputing an officer not below the rank of sub-inspector, other than the investigating officer who had submitted the preliminary report. Full stop. Consequently, FIR number 000116 dated 9/8/2025 was registered under the relevant provisions. Full stop. Relevant sections against the accused persons. Sections quote kar dena 3184, 3165, 3635 against the accused persons. Full stop. Petition number 1 is arrayed as accused number 3, and petition number 2 is accused number 2, right? Full stop. Learned counsel for the petitioner submits that petition number 2 is a retired government employee and is presently the chairperson of Shri Vijayapuram Municipal Council. Full stop. Petitioner number 1 is also a retired UCO Bank employee and the wife of petitioner number 2. Learned counsel, Mr. Deep Cham Kabir, learned senior counsel, further submits that petition number 2 has no connection whatsoever with the subject matter, and petition number 1. One is a wife. Petition number 1 has no connection with the subject matter, and that she is no way connected to the affairs of the Waqf, the affairs of the mosque, and that she has only been arrayed as a party to the complaint based on a based on the understanding of the de facto complainant in opening of the joint name of the account wherein it has been mentioned as Mr. and Miss Shahul Hamid.
With respect, my lord, it says Mr. slash.
Mr. slash Miss Shahul Hamid, which had given indication to the complainant that the wife, that accused number one, is also involved in the affairs of the mosque. Full stop. Though there is no iota of document or anything on record to substantiate that she is anyway connected to the affairs of the mosque. Full stop. She, it is further stated that she was in no way involved in administration of the concerned mosque, comma, Waqf board or any committee constituted under the Waqf board under the Waqf board. Full stop. Her implication in the present matter is solely with the intent to harass petitioner number 2. The full stop. The fact was categorically highlighted in the investigation report dated. What is the date of that? 11th September. Wherein it is specifically stated 11th July. Wherein it is specifically stated that petition number 1 has no involvement in the present case and has been unnecessarily implicated. Full stop. It is further submitted that petition number 2 has been arrayed as an accused solely due to political rivalry and that he has not committed any offense as alleged by the de facto complainant in the complaint. Full stop. Learned senior counsel further submits that this is a civil dispute between the parties and that the de facto complainant has filed the present complaint only with the intent to harass the present petitioners. Full stop. You file your report. The learned counsel, what is the generally, they'll file the report.
To be fair, my lord, I would pray for one extreme, which is a stay of everything. As far as he is concerned, he would usually say that we will not take any steps against them, but let's complete the inquiry. But the report will not be filed without a view of this honorable court. The report will come here.
Regarding investigation, I am.
Let them conduct.
Leave
Let
of
them
the court, final report
Yeah,
come. Without leave of the court, final report should not be submitted.
That's what I'm saying.
That-
I will not, I will ask for a stay. You will say no stay, let the investigation go ahead.
Yes.
The report will come here. So
Learned
not
counsel,
last-
learned counsel for the
Last.
respondent seeks and is granted. How much time?
15 days.
10 days,
15 days.
15 days, 15 days time, 2 weeks time to file his report. Full stop.
But then the petitioner wanted to make it protected in the meeting.
In the meantime, the petition number 1 and 2, there shall be no coercive action against petition number, no coercive steps shall be taken against petition number 1 and 2 till the for a period of 4 weeks or until further orders.
So for me, we won't have a.
8 weeks.
Mercy.
Yes.
Yes.
My some submission.
What submission? You want their custodial integration?
No.
That-
Lastly, I have submitted that part.
What
My
what's?
submission we have that.
I'm giving you opportunity to file your report.
Lordship.
What more do you want? Or your entire submission will be in your report.
Keep. I don't know, the workshop test will also direct to the order.
Yes, a copy of the present appeal shall be served upon the private respondent.
Also, this inquiry.
Affidavit of service shall be filed before the next date of hearing, list before the next available service.
One more thing is, comment your lordship to call for the LCR, because the original reports and documents which are not very legible here are in the LCR.
It is quite legible.
Then
Everything is here. The report is the most important thing. It's
Yes,
already here.
that report.
11th of July report.
That is a report. Page 1. Your lordship's copy it is legible, then that's
I can read it.
great.
Apply.
Yes.
Lordship, I am appearing for the writ petition. Lordship has directed the municipal authority to bring the record. They have brought the record.
Yes.
And the private respondent, I have seen the record. Private respondent already received the.
No, Your Lordship, I have, I have
On the
on my client
20th.
and showed that particular
September.
signature also, she disputes, that is not necessary.
Lordship, kindly see the signature in the wakalat and kindly see the
Yes, yes.
signature in
It's
the.
totally different. It is different.
I'm not an expert to,
Lordship, let this both things be sent to the expert. Let the appropriate direction may be given to the.
First of all, let them file an affidavit stating this thing. Showing the file will not do, they have not filed any report also.
this is regarding those unauthorized
Demolition.
demolition.
Yes, Your Lordship, they have.
The order is against you.
Yes, Your Lordship, and I have filed an appeal before the Lieutenant Governor.
On 20th.
Yes.
After filing the writ
Yes,
petition.
because after filing the writ petition only I came to know about
No, she
that.
has received it. The record reflects.
That is your contention. This is disputed.
This is the original man.
On 20th September 2024, she has received the order passed by the appellate authority.
It is very peculiar thing that the order is getting communicated by the municipal council.
Your
Not
Dhan,
by-
your Dhan Kumari.
I'm Sumitra. The Sumitra.
Please.
First,
First one.
Yes. That is a very surprising thing.
no, Lordship, because he is the appellate authority of
Appellate
municipal
authority is the
authority.
deputy
So,
commissioner. Now, the order is not communicated from the office of the deputy commissioner. It appears
through the building
Yes,
officer.
supposed to
It is not
municipal
a
council.
peculiar thing.
in any circumstances.
No, this is through the building inspector.
Yes.
But deputy commissioner's office.
That's all right. Um,
No, Your Lordship,
Order can be communicated.
See, Lordship, when the order is passed by the deputy commissioner, it is communicated from the office.
In the revenue cases,
In any case,
through deputy
in
commissioner.
any case, Your Lordship, if they say that this is the signature and it has been served, I am disputing it, Your Lordship. I will file an affidavit to that effect.
already filed an affidavit to
I
that.
will file an affidavit.
Lordship, in the
Let them
meantime,
come to the
municipal may be directed to.
Is there any stay? Is there any stay?
No state.
You have moved before the LG. Is there any stay?
I have already filed
No.
an appeal, Your Lordship. When the appeal is filed, Your Lordship, the decision is there of the dishonorable court.
Yes.
Lordship, kindly see whether lieutenant governor is
What-
having power to take the appeal. Section 187.
Does it go before the Lieutenant Governor? These appeals are filed before the Lieutenant Governor?
No.
Yes.
Show me the provision.
Permission is, Your Lordship, under the building bylaws.
Show me the building bylaw.
Yes.
Lordship, this is the section 187, building bylaw.
The building bylaws, it is there, 32 point. I have stated. It is there. 32 point.
This is to the Deputy Commissioner.
Yes.
I mean, there you are, so I'm not sure about it. It is certified. It is there.
With regard to 168, the secretary, municipal council has passed the order under section 168.
Yes.
Before the deputy commissioner within 30 days, that has been over. Now no second appeal,
It is
scope of
there,
no
Your
second
Lordship. It
appeal
is
is
there
there.
and- Kindly, Your Lordship, I'll just point out.
Show.
Yes. There, it is there. Regulation. Building bylaws, it is there.
Even I have a judgment of recent order passed by the honorable division bench. Let it be picked on Monday, I will bring that judgment.
Yes, I-
It is of 97 pages.
All right, let's have it on Monday.
It is the municipality place the building bylaws.
Monday.
It is under building bylaws, it has been done.
Monday. Not
Lordship,
today.
may I take back my money?
Yes, yes.
Lordship.
Madam, give back the book.
Yes, yes. I've already given them.
Then she has able, but
Yes, yes.
I have to.
Yes, yes.
leave of business.
Yes, yes. Monday, Monday. You'll have to.
Four. Substitute for three, or nothing about it.
Yes.
As per the respond number two.
Who's the petitioner?
Yes. And refer to complainant.
Lordship, this writ petition is not at all mentioned.
Yes.
He has to file a revision application before this on the.
27 I filed it because can you see the order sheets
Let him file.
And granting
revision
file
application,
a
Lordship, he
petition
will not object
for
for it.
discharge?
You file a revision, sir, does not maintain it. No, I will not pass any direction. No, file your revision petition.
The liberty will withdraw and file.
Learned counsel for the petition seeks to withdraw the present writ petition with liberty to file appropriate proceedings in accordance with. Not default, dismiss. As
I am for the petitioner. I am appearing for the office. I am for the private. Electricity
Yes.
connection was not my lot. I am in possession, I am.
yes,
But it is the dispute between landlord and tenant.
yes,
That landlord says.
yes. Landlord can't, how have you just withdrawn the electricity connection?
No doubt the electricity is the basic amenity for a consumer.
Yes,
But when the consumer is not exist,
that's all right, sir. Sorry,
So-
civil dispute, he exists. It totally exists.
that is the difficulty suppress the petition and not really passing it through.
Do you have an eviction order?
Suppression of that,
Do you have eviction order against him?
not the pending application.
Is there a eviction order? Then-
But he left the, no, imagine.
He has filed this petition, sir. He is here right in front of you.
Not the pending application.
Now he is with me.
There's a civil,
Pending application.
I cannot run the
doesn't matter. It doesn't matter. He is standing here in front of me. He says that he is a tenant.
Lordship, then the deputy commissioner find that page 18 may not be, transfer is clear, page 18.
Yes,
Page 18 first, Lordship, order number 18 may be seen.
yes.
Court passed and no objection order in my favor. No, that is subsequent. That is subsequent.
Yes.
Development. Suit is pending. What happened?
Sir, today the suit is pending.
Suit is
Do
pending.
you have an eviction order against him?
No, not-
Then how can you disconnect his electricity?
I hope what happened.
Show me the High Court order which
Yes.
says that you can disconnect the electricity of any tenant.
He is not in possession, that is the.
Sir, he's standing here. He's saying that those are disputed question of fact.
Lordship, that is the.
You grant him electricity connection immediately in 2 days.
Lordship kindly.
He allowed it, sir.
Record my submission, Lordship, thereafter any order.
Immediately grant electricity connection.
Lordship kindly, I am making
Yes.
submission from JERC regulation, Lordship.
Yes.
If a tenant is giving application to us,
Yes,
it is our duty to disconnect it. So it
Duty
is
to?
not that. Duty,
grant
as
it.
as per the JRC regulation, it is our duty because he has, the private respondent made complaint against my junior engineer before the secretary.
you grant electricity connection to
Lordship,
him
my
to make an
submission may be-
application.
I am placing the clause
Yes,
9.8, 9.9 and 9.10.
yes.
That may be recorded, Lordship. I don't have any objection to grant.
Lordship,
Take that.
But my submission may be recorded, Lordship. I have placed this thing.
Kindly appreciate
Only
the
one
judgment of the Honorable High Court with regard to this matter. That is suppression of fact. Suppression of lordship, today is the day. That is
Just
the
a
point
minute.
of state.
Yes,
Yesterday,
Lordship,
date was fixed.
No,
Today
we have
also
9,
date
10
was
and
fixed.
11 lordship. Can we have a look?
yes.
He is running a clinic there for
But
which.
these are different things, sir. We are not concerned with this. We are not concerned whether he is running the clinic legally, illegally. I am only concerned about his electricity. That's it.
Lordship, kindly appreciate. Now he is not running any clinic. He allowed his son to do a different business.
Sir, you have already filed a suit.
Lordship.
Get evicted. Due process of law has to be followed. You cannot use this mechanism of arm twisting to evict a person by disconnecting his electricity.
He is not in position. That is
He is in possession. He's making that statement. I'll record that.
Lordship, let a commissioner be
Lordship,
appointed.
No need to appoint any commissioner. And who are you? You are not concerned. Why are you speaking on his behalf?
No, I am not speaking on any behalf, anybody's behalf.
You do your job. Your job is to provide electricity. Don't get involved in civil dispute between people.
I am not the party. in this
Then why should anybody be appointed?
Holding it. My submission may be recorded, Lordship, any order may be passed.
Take down.
There are only one submission. Page
Yes.
number 34 is the Supreme Court judgment.
You forget Supreme Court judgment.
No, my lord, it is there. Page 38, last paragraph may be seen. Just one paragraph.
Their owner
You
has
want-
given no
My lord,
objection
I leave
certificate
to
for
you.
getting the.
I leave it to
electricity.
us.
You want electricity connection or
Yes,
you
ma'am.
want me to see Supreme Court judgment?
No. I want electricity connection. Connection should be restored.
I'm sure the Supreme Court doesn't say that illegally take away anybody's electricity.
Yes.
Never.
No, for giving electricity, Supreme Court is saying he cannot disconnect the electricity.
So what is this court saying, sir?
This-
Anything contrary?
No, same thing.
Then why are you showing me that? It improves your case.
It will improve my case. madam.
Why?
Yes, sir.
Do I have a contrary view
No.
than the Supreme Court?
No, I am sorry. I'm sorry.
I'm having the same view which the
Yes,
Supreme
yes.
Court is having, sir. Take down. The petitioner has preferred the present writ petition seeking a direction against the respondent authority for restoration of the electricity connection bearing consumer number F1 2024 in respect of his tenanted premises situated at Lamba Line Village, Dairy Farm Junction, Port Blair, South Andaman. Full stop. The case of the petitioner that he is a doctor by profession and is running a clinic at the aforesaid tenanted premises, which belongs to the private respondent, bracket landlord, full stop. Landlord-tenant dispute is presently pending between the parties before the Court of Learned Joint Civil Judge, Senior Division, Port Blair, full stop. While order dated 9/7/2025, the court permitted the petitioner to deposit rent before the court and further directed the private respondent to issue a no objection certificate to the petitioner for obtaining registration under the Clinical Establishment Regulation Act 2010 within 15 days. Full stop. The court also clarified that the private respondent shall issue NOC within the stipulated period. The petitioner will be at liberty to produce the said order before the competent authority for registration under this act. That if the private respondent failed to issue a no objection certificate, the petitioner will be at liberty to show this order before the competent authority. Full stop. In the meantime, however, the private respondent moved an application for disconnection of electricity connection to the said premises. Full stop. Consequently, on 28/8/2025, the respondent authorities disconnected the electricity connection. Full stop. Aggrieved thereby, the petitioner has preferred the present writ petition. Full stop. Learned counsel for the private respondent submits that the petitioner is no longer in possession of the property. The said fact is disputed by the petitioner, who states that the civil dispute between the parties are pending before the civil court, full stop. Learned counsel for the respondent submits that the disconnection has been effected at the request of the consumer, i.e. the private respondent. He states that in case a request is made by the consumer, they are under bona fide duty to disconnect the electricity in terms of JERC regulation number
9.8, 9.9,
9.8, 9. In terms of JERC regulation, 2018 regulation,
2018.
JERC 2018 regulation in terms of clauses 9.9.8
8.9, 9.10.
and 9.10. Full stop. Full stop. However, the petitioner, no, full stop. Though the respondent, the respondent administration states that if the petitioner applies for the electricity connection, the same shall be, the application shall be considered in accordance with the rules. Full stop. The
That's a petitioner cannot apply for the electricity gun because owner has to give no objection. It is the recorded tenant. He is the recorded tenant. He is not.
in term, I will pass an order that you will give him electricity connection.
I will provide the electricity connection. That's
You give a no objection. Give a no objection to him.
Private
See-
maybe directed what would be better to restore the electric connection.
Connection is already there. No?
Then you give this undertaking to the court. At this stage, learned counsel for the private respondent undertakes that he shall make an application before the respondent.
number 2.
Respondent number 2, she will make an application within 2 days before respondent number 2 to restore the electricity connection and shall not fall to these kind of methods to evict the petitioner from the said property. Full stop. Since the landlord tenant dispute is already pending before the civil court, the private respondent, i.e. the landlord, will not make any attempts to disconnect the electricity connection of the petitioner without due process of law. Full stop. The respondent number 2 is directed to re-energize the said electricity connection within a period of 2 days after the submission of application for restoration by the private respondent.
That's it.
Full
Within
stop.
1 day.
Within 1 day.
Right.
Within 1 day. Full stop. With the above direction, the presented petition is disposed of. Affidavits have not been.
Engineer is very near to the house of.
Don't subject your people to this.
Not even one, the landlady is not giving no objection, then I will give it 3 days.
3 days. 2 days. ka 3 days.
Leave is there. Lordship. Tomorrow leave, Saturday leave, then Sunday. Monday he will apply. Tuesday we will provide you. Lordship,
Within 3.
Lordship, my
3
instruction
working.
will be kept with.
I've already recorded. Give the instruction. I've already recorded your submission.
Private respondent had made complaint up to chief secretary because we were not.
Instructions filed by the
We are
instructions.
not disconnecting the electricity.
Instructions
connection.
filed by the respondent number 2 is taken on record.
Okay, what is it? You are 31 or 25. And therefore the offensive party number 2.
Yes. Are you okay? See, I don't want to push you if you're not able to see things.
Some citation I couldn't. Some citation because with regard to they may ask that I couldn't. Actually.
You're the petitioner. What citations you could not go through, madam?
Someone case.
Yes.
Someone case also discharge. If discharge is not permitted, caution. For this. That is that. Some citation is there, Subramanian's case, and Dalat Prasad case, and Balandar's case.
Yes.
These are there. But also. But different how. And there is a civil dispute that is with regard to that.
It's a completely civil dispute, madam.
Civil dispute is there, status quo was there on the, when the status quo was passed, thereafter entered into 447. 323 is saying, 447 is saying, when I am in, I'm residing there, that's why status quo was granted by the civil court, all these things are there. All things are there. They entered after the status quo.
Yes.
Court order is there.
Mr. Jaipal. No, I'm just saying that, she is having issues with her eyes.
Extension of extreme modern worship.
What do I, that's the reason I have kept it. Why, she's your colleague.
But I borrowed the words
I-
from my lord.
I have-
borrowed the words from my lord. What Baradov said here on the last occasion, I borrowed the words. Baradov said that if the matter is taken up finally, perfect. If it is taken to the next circuit, extension will not be accorded. I borrowed my lord's word.
Criminal civil dispute doesn't entitle you to resort to fighting.
Position was handed over. Position was handed over and deciding there.
Might be residing. We are not getting into your civil disputes. We are only looking into the criminal action.
So that after the status quo, when the status quo was granted, all these things cropped up. Prior to that, nothing is done. Prior to that, they came to enter and I filed the civil suit. After filing of the civil suit, again,
Yeah, argue, madam. We'll try to finish it.
that then Monday, started.
Monday.
Today I will start and take
It's not such a big issue that you will carry on till Monday.
some citation.
All right. All right, start.
The opposite party that filed a complaint before the lower court. Wherein, under sections 447, 323, 504, 506, 352, 354, and 34 acts. After filing of the complaint, the court has taken cognizance and my lord,
Lordship, before this start, Lordship, I have just now received a message from my home. Actually, I have left my mother in hospital. She is having some issue. My other matter may be taken up on my
The XTD matters.
electricity. I will be permitted.
Yes.
and that after taking the complaint, it was section was 448, 323, 504, 506, and 30.
Yes.
Summon was received by the petitioner And petitioner entered to the date and filed an application.
Yes.
In the section 245.
Yes.
Application is at page 43.
Yes.
By saying that, first,
This is what you're challenging the discharge order, right?
discharge was another, but it is someone case also. If it is not discharge, can be a fashion that can be converted to that. Okay, I'm paying for that. But in the discharge application has mentioned my lord, because here my lord, the opposite party number 2 is the sister-in-law of the of the 1K Tarupalli.
Yes.
The accused person's landlord has made an agreement. Had
Yes.
executed an agreement.
Yes.
So that it was executed.
That is your father-in-law who had.
Father-in-law.
Yes.
Father-in-law. Executed an agreement. Thereafter, my lord, sale deed was prepared. It was executed,
Yes.
but could not be registered. During those period, my lord, the father-in-law was sick. He could not reach order to register, and all of a sudden he expired.
Yes.
But in the agreement was at the time of executing the agreement, the father-in-law has handed over the possession, 1,000 square meter.
Yes.
But now the after the execution, he has he has kept these persons in the house of that property. In that property, now the accused persons are residing on the basis of the agreement. Rent agreement. One fine day, that is on 1/2/2023,
Yes.
complainant first
Yes.
tried to enter into the suit property. So the complainant's wife, she made a complaint before the authority, and thereafter, after giving the notice, the civil suit was. In the civil suit, stay was granted on 12/4/2023. 12/4/2023. After granting the stay order, the complainant along with her son had been to the suit property on 15/4/2023
Yes.
and started asking to vacate the premises. And there was a hot dog color, and the accused persons, they made a complaint. They made a complaint before the police authority on the same day, 15/4/2023. NCFI was chalked up, and some minor injury was there. That was after NC derived. On the subsequent day, because the complainant, they also went to Raleigh complaint, there was no affair. On the second day, 16/4/2023, they made one complaint by saying that.
Page 39. Page 39, madam.
Yes, this is the complaint.
Yes.
This was filed on the basis of that no affair was found. This was the later complaint on 16/4. This year, my lord,
Yes.
that 447 house was passed. But this year that I was there, that's why this status quo was there, 12/4. 12/4 status quo was granted because I was there, I was apprehension that they will remove me, that's why I filed a suit also, and then after I obtained a status quo order. So this 447, first, the 447 ingredients The case was already in possession. There's no trespass or something. They were residing there. There is an agreement between the landlord and tenant. It's not a landlord, but he has purchased the land. And sale agreement is there, sale agreement, that suit is stipulated. First matter, 447, with regard to 447, what they are.
Yes.
And we get back next day, because 15th for already I made a complaint, but the next day, they have
16th.
just counter complaint they have made.
Yes.
Just a mere counter, because I have made a complaint, that's the second day after that, they made a complaint.
Yes.
Complaint. And with regard to 323, also, medical document they have filed.
Yes.
It's not said that I have done that. No. In the
Medical,
document also it is not.
medical report doesn't say that you have done something. It only shows the injury. It's only concerned with the injury, not with the person who has caused the injury.
Final, that is also there. So we are saying 323.
Yes.
So if 323 is there, they could have made a complaint on the same day. On the next day, after everything, thinking everything, next day they went and they tried to lodge a complaint, which was not taken by the
Yes.
police officer.
Yes.
So, my lord, this is totally a abuse of process. Just to harass, because
Judgments are not required in this matter. No judgments are required. What judgments you're going to cite? What? Adalat Prasad doesn't cover your case. What covers your case? We'll finish it off. Yes.
that magistrate had no power, that is their. So, Rashi can be filed.
That's all right. We are not getting into that issue. We are only looking into the revision. Okay.
And the complaint and the medical report.
That is your argument, Maynard.
And it is stated that in the order by saying that accused persons are not the, not filed. I have balanced the agreement also by saying that no, we are deciding there, because this person, landlord, he is posted presently as unrepresented, so outside person. And he is personally is not deciding there, but his man is deciding there.
Yes. Yes, Mr. Japan,
I know the state first.
you have to say something, no?
Discharge application as and when is taken up. But should the court, concerned jurisdictional magistrate court, confine its finding to the complaint and the material relied in the complaint. Lord, would see the discharge application.
Yes.
The accused have brought certain documents more.
Yes.
This was taken care of by the trial court. Lord, would see the trial court's finding. But the trial court said even the trial court went a step ahead, said that since it's not permissible under law, because discharge would be confined to the facts pleaded in the complaint. It's something like order 7, Lordship. Facts need to be seen. No written statement, nothing needs to be seen. This is something like that. It is akin to that. But the trial court went a step ahead, and Lordship, it has clearly said, because they have argued that there is a civil suit, there is a status quo operating in the field. The trial court clearly held, Lordship, that the accused being not a party to the suit, but they are not bound by the orders, even the complaint. So, Lordship, the trial court have rightly passed the order which requires no interference, because I have read out a case, cognizance was taken, these are the matters to be gone into in the trial, the entire issue will be thrashed out. It's not a fit case, Lordship, where discharge can be directed.
All right, take down. The petitioner, by way of the present revision petition, is assailing the order dated 9/6/2025, passed by the learned judicial magistrate first class 2, Port Blair, in CR case number 62/2023, whereby the application filed by the petitioner under section 245 CRPC seeking discharge was rejected. Full stop. Respondent number 2, bracket में कर दो, de facto complainant, bracket close, filed a complaint under section 200 CRPC alleging that the petitioner, along with 2 other persons committed offences punishable under section 447, 323, 504, 506, 352 and 354 read with section 34 of Indian Penal Code. Full stop. The case of the de facto complainant is that she was residing with her mother-in-law and son at a house constructed on land survey number 257 Ravindra Nagar village, Little Andaman. Full stop. However, for the purpose of her son's education and for availing medical treatment for her mother-in-law, she temporarily was residing at a rented accommodation at Pahadgaon village, Port Blair, South Andaman. On 5/4/2023, a fire broke out at her house at Ravindra Nagar, destroying all her belongings and rendering the residential structure uninhabitable. Full stop. Consequently, she decided to reside temporarily on their own land measuring 100 square meters at survey number 203 Ravindra Nagar village. Full stop. 15/4/2023, when the complainant, along with her mother-in-law and son, proceeded to the said temporary accommodation, they found that the accused persons, including the present petitioner, were in unauthorized occupation of the same. Full stop. The said land originally belonged to complainant's father-in-law, and the temporary structure was constructed by him during his lifetime. Full stop. Hence, according to the complainant, she and her family members were lawful owner of the premises in question. Full stop. When she and her family members asked the accused persons to vacate the structure, the premises, the latter allegedly abused and assaulted them, thereby committing the aforementioned offences, Since the police refused to register her complaint, the de facto complainant filed a private complaint under section 200 full stop. CRPC, before the learned trial court, full stop. While order dated 9/8/2023, the learned judicial magistrate first court, Port Blair, took cognizance of the offence and issued summons against the accused persons. Full stop. The accused persons thereafter filed an application under section 245 of CRPC seeking discharge. Full stop. While the impugn order dated 9/6/2025, the learned trial court rejected the said application. Aggrieved thereby, the petitioner accused number 1 has preferred the present revision application. Full stop. The case of the petitioner is that they are tenants in the premises in question under one Shri Bidhan Chand Poddar, who is the landlord. Full stop. The petitioner submits that complainant's father-in-law, late Shri Karupaya, had agreed to sell the property to Shri Bidhan Chand Poddar, but expired before the transaction could be completed. Full stop. Thereafter, the legal heirs of late Shri Karupaya, including the complainant and her mother-in-law, refused to transfer the property, leading Shri Bidhan Chand Poddar to institute a civil suit against them. Full stop. The learned civil court has also passed a restraining order against the complainant and her family members. Full stop. Despite this, the complainant and her family allegedly attempted to forcibly enter the petitioner's tenanted premises and to evict them. Full stop. The petitioner claims to have lodged a complaint before the concerned police station on 15/4/2023 regarding the said incident. Full stop. It is the contention of the petitioner that the dispute between the parties is essentially civil in nature, and the initiation of criminal proceedings amounts to an abuse of process of law. Full stop. On this ground, the petitioner prays for setting aside of the impugned order. Full stop. Learned counsel for the respondent states, respondent number 2 states that the present proceedings are independent proceedings and are not related to the civil disputes between the parties. Full stop. He states that the impugned order has been rightly passed by the learned court. Full stop. This court has heard the arguments advanced by the parties and has perused the record and document placed on file. Full stop. It is not in dispute that civil. It is not in dispute that a civil dispute is already pending between Shri Bidhan Chand Poddar and the legal heirs of late Shri Karuppaiah with respect to ownership and possession of the property in question. Full stop. The petitioner claims tenancy rights under Shri Poddar, while the complainant asserts that the property was owned and occupied by her in-laws. Full stop. Undoubtedly, the question of title and lawful possession is a matter falling within the exclusive jurisdiction of civil court, and such issue is not to be adjudicated in criminal proceedings. Full stop. However, merely pendency of a civil suit or existence of a rival claim over property does not, by itself, preclude the initiation of criminal proceedings where allegations disclose commission of cognizable offense. Full stop. The scope of the present proceedings is limited to examining whether the prima facie material exists to proceed against the accused in respect of the alleged incident dated 15/4/2023. Full stop. It is an admitted fact that an altercation took place between the parties on the said date. Full stop. Both sides approached the police with their respective version of the incident, and subsequently the complainant availed of a statutory remedy under section 200 CRPC. Full stop. The learned trial court, after considering the materials placed on record, formed an opinion that there were sufficient grounds to proceed against the accused persons and accordingly issued summons. Full stop. At this stage, this court is not expected to meticulously examine the veracity of the allegation or to weigh the sufficiency of evidence, but only to see whether the complainant, on the face of it, discloses ingredients of the alleged offenses. Full stop. The plea of the petitioner that the matter is purely civil in nature is devoid of merit. Full stop. Even if there is a civil dispute, allegations of criminal trespass, assault, intimidation, and outraging of modesty are matters that fall within the realm of criminal law. Full stop. It is settled position of law that civil and criminal proceedings can run concurrently if the facts give rise to both civil liability and criminal culpability. Full stop. Thus, the pendency of a civil suit or order of restraint in civil proceedings does not by itself extinguish criminal liability, comma, if otherwise made out. Full stop. At this preliminary stage, it cannot be held that the allegations are inherently improbable or manifestly absurd so as to warrant discharge under section 245 CRPC. Full stop. In the considered opinion of this court, comma, the learned trial court has rightly declined to discharge the petitioner, full stop. The impugn order does not suffer from any illegality, comma, irregularity or perversity warranting interference in revisional jurisdiction, full stop. The trial court has exercised its discretion in accordance with settled principles of law, and therefore this court is not inclined to interfere with the order of the trial court and does not find any reason to substitute its own view in the absence of any manifest error in the impugned order. Full stop. Accordingly, the revision petition is found to be devoid of any merit and is hereby dismissed.
Very short point is there. The conditional order was passed by the subjudicial magistrate, and that the initiation was there. The proceeding was initiated by the subjudicial magistrate in 2020.
Noise pollution.
Yes, till now it is pending. I am just asking a direction to the subjudicial magistrate to
Control
conclude
the
the
receiver
proceedings.
number one.
Who's for the subdivisional magistrate?
Subdivision two.
My senior appears on the-
Who's your senior, madam?
Rakesh Kumar sir.
Where is he?
He's out of station.
He's not here. He had appeared online. He left yesterday. At the request of respondent number 2 and 3, let this matter be listed before. I know, but
Yes,
he has to be here. Let this matter be listed before the next available sir. Yes. Yes.
My instruction is that the report of the Vivek committee is still under examination with the ministry.
When will you do it? Take a final call. When will the final call be taken?
That is the instruction that is still under the examination of the with the ministry.
Date on the petitioner in the present writ petition is alleging is challenging the order dated 20. What is the date of the order? 24 or 26? What is the date of the impugn order? Are you the main counsel? Please before the next, at the request of the party, let this matter be listed before the next available circuit bench. At least read the file, sir. At least some assistance.
My report will be on this.
Matter my senior appears on job correspondent before next one. Matter in this matter, my senior behalf of the petitioner.
Yes. Yes.
Why not this petition? One of the three petitions.
Yes.
The same similar cases, the two matters already heard by the court number 1. Which directed the filing of an affidavit in position.
Where's the order? What are your instructions?
Affidavit,
Yes, show me. This is regarding putting up the shutters, right? This means the matter is over. Nothing survives.
Kindly requested this direction will be given these.
There is no direction, madam. Listed before the next available second. At the request of the parties, let this matter be listed before the next available. Nothing is here. All electricity matters since he had some family issue. Mr. Mishra. Monday we'll have. So electricity goes till 21. 20 till 20. None for the party. Yes. Are you 21? None for the petition. Let this matter be listed before the next available circuit bench. Yes.
Matter which has gone for mediation now that followed up to the registry. It has been sent to mediation. Mediator has been appointed. Date has been fixed. Most probably it's on 10. So now the matter can perhaps go out of this. I'm liberty to mention once a mediation report comes.
Learned counsel for the petitioner states that the present matter is pending before the mediator. Let this matter go out of the list with liberty to the petitioner to mention for inclusion.
So for the state. Sorry.
Give your appearance.
And for the state.
Yes, give your appearance. Give your appearance.
My lord, item 23, I am seeking extension of time to file opposition, my lord. On last extension.
Who's there for the petition?
Added respondent.
In the connect 24, I am for the petitioner. For 23, the sir is there for me.
Where's Mr. Tabrez? Any junior of Mr. Tabrez?
23 and 24, I am seeking extension to file opposition on behalf of the added respondent, my lord.
None for the petitioner. Learned counsel for the respondent. Added respondent.
Added respondent.
Added respondent seeks and is granted liberty to file affidavit in opposition. 2 weeks time to file his affidavit in opposition. Reply if any within 1 week thereafter. This before the next available circuit.
Obliged, my lord.
Item 24.
For same.
24.
Same order, my lord.
Petitioner is there. So just
Yes.
take his appearance
Same prior.
and send.
25, 6 of them.
Yes.
My previous is to the private response.
Yes.
Senior appears on behalf of the administration.
What do you want, man? Next circuit.
Next.
I am appearing for respondent number 1 and
At the request of the parties, let this matter be listed before the next available circuit.
obliged, my lord.
In 26, 9 1 for 123.
Yes.
My lord, the senior appearing for the petitioner and being for Shraddha, so
So it won't be possible. What is there in the matter?
I am for the official respondents, my lord.
Yes. Have you filed your
My lord,
affidavit?
pleadings, yes, my lord.
PDX complete?
Complete, PD is complete, my lord. King order is
Who's your senior?
maybe that was
Who's here? Where is he? What is the issue, sir?
There was a decision taken by the Deputy Commissioner, Secretary Revenue. It is under challenge before this honorable court.
You want next circuit? At the request of the parties, let this matter be listed before the.
Obliged, my lord.
okay.
So one, 24, and then 28, and then 3 on 4,
Your Lordship,
I'm very much.
Your Lordship, item number.
Praying for?
27.
Petitioner. For the petition.
Your
Yes.
Lordship, in this matter, my senior appears on behalf of the respondent. I pray it may be taken in Monday or in the next session. It's a ready matter, Your Lordship. Item number 27, 28, and 29, Your Lordship.
Yes.
It's all right. If the
Monday is the last working day. What is the issue?
The issue here is with regard to, they are the contractual employees working Anganwadi. And they had been removed from their service without any prior notice and their contract has not been extended with regard to that. There is a scheme, service extra scheme under which they have been appointed. And the opposite side, that is the respondent authorities, they are stating that there is certain age bar. But similarly situated candidates have been appointed despite the age bar. So that is the case.
Or we'll try on Monday. That's not today. These are 20, 26, 27, 28.
27, 28.
27 and 28.
Then 29, that was the 6, 7, 3, and 24.
I'm paying for the petitioner, Rashid. Let us read to the next one.
At the request of the parties, that this matter be listed before the next available second.
Then 30, that was the
Your Lordship, item. Your Lordship, in item 30, Your Lordship, I am filing my affidavit in opposition, Your Lordship. My department officer, he's present over there. We will be giving the hard copy of the opposition, Your Lordship.
Who's for the
My lord, I am for the petitioner, my lord. Leave may be given to file affidavit in reply to that effect, my lord.
All right, learned counsel for the you appear for respond number, Ms. Rajeshri.
For the CGST authorities, Your Lordship. All the respondents, Your Lordship.
All right. You had already taken time 2 weeks.
Your Lordship, I have filed affidavit in opposition is filed, Your Lordship. My department officer is present there with the original copy of the opposition, Your Lordship. Kindly, he may be permitted to give it to the court in the court's record, Your Lordship.
Affidavit in opposition filed by the respondent is taken on record. Learned counsel for the petitioner seeks and is granted 2 weeks time to file his reply to the said affidavit in opposition. List before
Affidavit in reply.
the second bench.
Deeply obliged, Your Lordship.
Grateful to you, lord.
Then 31, or the 25, or the 25.
Your Lordship, in this matter, my senior appears on behalf of the respondent. We
Yes.
time to.
Election is for them to file.
Yeah, file.
No, Your Lordship, seeks 2 weeks time to file affidavit in opposition.
Learned counsel for the respondent administration seeks and is granted further time of 2 weeks to file his affidavit in opposition. Full stop reply to the same if any within 1 week thereafter, list before the next available second.
Okay, Your Lordship.
Yes, sir. Yes. Then 32, you have 28, 25.
I have regard to indicated that I not taken a 10. Java involves since we got Mosque also, then it starts at 5, paying for.
Not this time.
I'm enjoying a linear model. That linear model is there till the end of the month.
Entry order granted earlier shall be extended further till 31st of November. List before the other request of the parties that this matter be listed before the next available circuit bench. Entry order इसके बाद granted earlier is extended till the next.
Then 33, W53 or 25.
The respondent. The extension of time to file our affidavit. We have already filed our opposition, my lord.
Learned counsel for the petitioner seeks and is granted further 2 weeks time to file her reply to the affidavit in opposition. Right? List before the next available circuit bench.
I'm appearing for respondent number 2, 4, 6, 7, and 8.
Who's for the petitioner? 34. None appears for the petitioner. In the interest of justice, adverse orders are deferred. List before the next available circuit bench.
And for the rest of
Yes, Ms. Babita.
My lord has fixed this matter because the advocate commissioner was appointed to demarcate the landed property, my lord. If my lord sees the last order and Ms. Shipra Mandal was appeared also before my lord on the last occasion. So we have received a copy of writ, my lord. And the demarcation and the commissioner local inspection is fixed.
So you conduct the inspection, you have not conducted it.
No, not me, my lord.
So, yes, yes.
I am for.
What happened?
Have
You have given the notice now?
I have received now, September, I have fixed on 11.
Ms. Shipra Mandal, the special officer, appears and states that she has given notice for inspection,
And we have received it.
which has been fixed on
13 September.
13th of September 2025 at 12 p.m.
11 a.m.
11 a.m. 11 a.m. Full stop. Let this matter be listed before the next available circuit bench to enable the special commissioner to file her report after conducting the inspection. Final inspection in conduct inspection as per the earlier order. As per the earlier.
Sir, I'm sorry to indulge, the matter in which a special officer was appointed.
Yes.
But there is an interim order which was operating till last day of the August. That needs to be extended.
But it has not been extended earlier.
And because the Lord had said that unless I comply with the orders by depositing the keys, by supplying the documents, the Lord had fixed the matter for this reason. And that is done, the Lord will consider it, the Lord had said.
Nothing is happening here.
Well,
They are not doing anything.
but still not, there is a judicial order being passed now that needs to be extended, otherwise, Lord should. Highly should happen.
Which is the first order by which it was extended.
Yes. Just mark.
Justice Chanda's order.
Yes, yes, yes. Yes.
4th April.
The parent order is
4th April.
4th April, the extension order is 6th August, last extension, 6th August.
The interim order granted earlier, dated July 8, 2025, which had been extended from time to time, is further extended till 31st of November 2020.
I'm extremely.
Okay.
Next. Sir.
I'm waiting for the petitioner.
My lord, I am seeking extension of time to file opposition, my lord, on behalf of the respondents.
Learned counsel for
The
the
last circuit, they had not for night.
One last chance may be given. my
learned
lord,
counsel
before-
for the respondent administration seeks and is granted one last opportunity to file his affidavit in opposition. Reply within a period of
2 weeks, my lord.
within a period of 2 weeks. Affidavit in opposition within a period of 2 weeks. Reply, if any, within 1 week, 1 week thereafter, less before the next available circuit bench.
I pay for the respondent, my lord, I am seeking extension of time to file opposition, 1 week
Aye.
time.
Same order करना है, हाँ.
Obliged, my lord.
Seeks and is granted one last opportunity. Next, sir.
Obliged. In 38, W 196,125.
38 also I am seeking extension of time, my lord. Last opportunity.
Who appears 38? None for the petitioner. Have same order.
38, go.
Next, sir.
Obliged, my lord.
In 39, W 225.
My meetings are completed, let a very fix for you. My senior
Today?
on behalf of this one. My senior here on behalf of this one.
At the request of the parties, let this matter be listed before the next available circuit.
38.
40.
41.
This was 39, 40, 41, right, madam?
Yes.
39, 40, 41.
In 42, W 244,125.
42, my lord, I am seeking extension of time to file AO.
By mistake, my name is appearing in the cause list, my lord, maybe delete.
My name may be recorded, my lord.
So balance it. Can't be deleted.
You are Mr.
Siva Balan.
Where is your name, Ms. Babita? Which
Cause
order?
list, my lord.
In the cause list. Just make that correction. Inadvertently, name of Miss Babita Das is reflecting in the cause list. Though Mr.
Siva Balan.
Shiva Balan, VD Shiva Balan appears for the respondents.
Seeking extension of time to file opposition.
Necessary correction shall be made by the registry. Full stop. Learned counsel for the respondent, Mr. VD Shiva Balan, seeks and is granted one last opportunity to file his affidavit in opposition within a period of 2 weeks. Reply, if any, within 1 week thereafter. List before the next available second.
Any obliged, my lord.
In 43, W 265,125.
And for the respondent.
43,
Madam, here the petitioner was directed to file the writ of reply to my submission.
yes, Ms. Mandal, where is the reply?
And for the private response.
Who's for the petition?
Mr. Sabir.
None for the petitioner.
This application is not being. I have raised this point in my application.
What to do? He's not here. Should we keep it for Monday? Not today.
In 44, W 290,125.
I am appearing for the respondent, my lord. Please, we have filed our reply, opposition.
You are filing?
Yes, well, already filed,
Already filed.
my lord.
They have sought time to take a file reply? None for the petitioner. In the interest of justice, adverse orders are deferred. Let this matter be listed before the next available circuit.
Obliged, my lord.
In 45, W 303,125.
I think 45 counts in your best to be picked up. This is and their opposition. Your Honor, in this matter, my senior appeared from the office stay for 2 weeks time for filing affidavit in opposition.
Learned counsel for the respondent administration seeks and is granted one last opportunity to file their affidavit in opposition within a period of 2 weeks. Reply, if any, within 1 week thereafter. List before the next available circuit.
In 43, W 306,125.
But in this matter also, there is a direction. Some of the respondents are filed. We have filed the affidavit in opposition.
Who has not filed?
Respondent have not filed.
Who appears for the cooperative society? Who, any junior of Mr. Tabre is here? You are for respondent number 3. Learned counsel for the respondent number 3 seeks and is granted one last opportunity to file his affidavit in opposition within a period of 2 weeks. Reply, if any, within 1 week thereafter. List before the next available circuit. Give your appearance.
Here.
I'm referring for official respondent number 112.
Was this, my lord, wrongly my name is appearing in the state of violence
Ms. Bhavita Das states that
in the cause list.
inadvertently her name has been appearing in the cause list. Registry is directed to make necessary changes.
There are private respondent also, my lord.
VD Shiva Balam appears for the respondent.
1 to 6.
1 to 6. 1, 2 and 6 or 1, 2, 6?
1 to 6, my lord.
1, 2 and 6, huh?
No, my lord. 1, 2, 3, 4, 5, and 6.
1, 2, 3, 4, 5, and 6. 1, 2, 6. You have filed your affidavit?
No, my lord, seeing time.
1 to 6. And seeks and is granted further 2 weeks time to file his affidavit in opposition. Reply, if any, to the same within 1 week thereafter, less before the next available sir.
Oblige, your honor.
My lord, I am for the respondent, my lord, I have filed my opposition. Because it has come up because I filed with the party. Fine.
Learned counsel for the petitioner seeks and is granted.
My lord, I have filed.
It's here. Learned, the affidavit in opposition filed by the respondents is on record. Learned counsel for the petitioner seeks and is granted 2 weeks time to file her reply to the affidavit in opposition filed by the respondents. List before the next available circuit bench.
Oblige.
49,
Who's there? 49. Not today, Monday. 50.
My lord, I am for the respondent. The extension, my lord, first extension.
Learned counsel for the respondent, Ms. Vita Das seeks and is granted 2 weeks time.
Wow.
2 weeks time to file her affidavit in opposition. Reply, if any, within 1 week thereafter. List before the next available.
Oblige.
Item number 4. Learned. उस पे एक line add कर देना item number 4 में. Liberty is granted to the petitioner to take back the certified copy and to place on record Xerox copy of the same. This will take back the original copy and supply a Xerox.